So you're still chairing judiciary in the morning, Eric, or?
Yes.
Okay, vice chair hasn't taken over yet? Welcome everyone back to Senate Education. It's 2:39 on Thursday, February 22nd. We're shifting our attention to S220, sections 7 and 8, having to do with criminal threats. This is the public library, this is the library bill, and then section 8, possession of dangerous or deadly weapon in a school bus, school building, adding public library or on school property. Mr. Fitzpatrick, I don't know if you're comfortable taking us through these, reminding us what's in these two sections, or you, that's,
I could certainly do that with respect to the possession of firearms at libraries section.
let's do that. Let's start with that.
That's the one I
Great.
looked at.
Great.
But yeah, so for the record, Eric Fitzpatrick with the Office of Legislative Counsel, here to talk with the committee about a couple of sections in S220 related to libraries and criminal provisions. Nice to see everybody. Thanks for having me.
Yeah.
So the provision related to possession of firearms in public libraries is actually a proposal to embed libraries within an existing provision of law. And we have an existing law right now. There are a number of what are sometimes called sensitive locations. These are location restrictions on the possession of firearms. And existing law has several of those. For example, courthouses has been on the books for a long time, quite some time, and this existing section on school buildings and school property has also been on the books for a long time. I believe it was last year that hospitals was passed.
Right.
So remember that was added to the sort of concept of sensitive locations, so location restrictions, they're sometimes called. So my understanding of what you're looking at in S220, at least this piece of it, is to add public libraries to that list of potentially sensitive locations. And that's a criminal provision. So the way the statute is written right now, it has to be knowingly, first of all. It's a mens rea, which is an intent language is what that means in the criminal law. In other words, you can't just sort of accidentally have it on yourself if you don't realize that it was there. You must know that you had it. But there are different penalties depending on whether or not, at least with respect to the existing law, the possession is in a school building or on school property. And I think that's sort of the structure that's been in place for a long time as well. The proposal, as I read it, is to add public libraries and public library property to that same sort of scheme that you have in existing laws. So the prohibition on possession in a building, the library building, be a 3-year felony, and the public library property has to be with intent to injure another person. So having it at all in the building is prohibited, and having it on property with intent to injure. So you can't have it in the building at all, presuming that you know you have it. In property, though, and I think it was historically with respect to schools, the reason for that distinction was that someone, and the statute's been on the books for quite a while, but for example, someone may go to pick up a child at school and they have their hunting rifle in the car. They're not going in the building, that's right, but they're just intending to pick up the child and go home. And so there wasn't any intent to injure anybody. So the idea was not to prohibit that kind of behavior. It's not what I think the statute was originally trying to get at. So the proposal is to add public library to that same kind of setup, that can't have a firearm in the library and you can't have a firearm on library property with the intent to injure anybody.
So again, you could pull up, you can have a gun in your car from hunting, return a book, pick up a book, pick up a kid, go in, all that stuff.
Exactly.
Center our shame.
Thank you, Eric. I think, one of the points that I'm thinking of that, I agree with is something that Senator Williams raised a while back. I think it was, I don't want, correct me if I'm wrong, but I think there was a library in our district where the librarian was concerned if, someone who regularly is carrying a firearm enters the library and nearest barracks is an hour away. What I'm seeing on page 6 is that, line 1 is that essentially the directors of a library can authorize possession if that's what they want. And that's how I'm reading that. Is that Am I reading that correctly? Or,
That's what I read the exactly, yes.
Okay.
There could be specific instances where they could decide whether because of an event or whatever it may be that they want to permit it, yeah.
would they also be able to permit it generally if that's what they want?
The way I noticed that I'm looking at the bill as introduced, so I may not have the exact wording. The wording I was looking at was authorized possession or use for specific occasions or for instructional or other specific purposes.
Yeah.
So
That's what I have.
I think that you're right, it could be more general, for example, some category of purpose. That wouldn't depend on a particular occasion, but whatever that might be.
Yeah. Okay, thanks.
Yeah.
So to go further with what my town librarian's testimony was that she has people, it's a, your second amendment right, you can open carry in the state of Vermont. Right now, she didn't support this provision of the bill because she didn't want to have to, she or her employees have to be the enforcement arm if they do see somebody. Because in a rural area, you could wait an hour to 2 hours before you see any law enforcement. So there's, I guess the point she was making was, well, if we make it a law, then somebody has to enforce it. It's not gonna be me. So,
Well, you kind of raised two issues there. That, the second issue of who should enforce, and you're right, it raises the issue of who would do it. That's more of a policy question for the committee. But you were kind of getting at the constitutional aspect. And I was gonna get into that issue next. This does raise constitutional concerns. And the reason for that is that you probably have heard that over the last couple of years, there's a new United States Supreme Court case called New York State Pistol and Rifle Association versus Bruin that has established this new test for analyzing firearms regulations and firearms. And in order for a law to be constitutional under the Second Amendment, the analysis that courts have to go through is to decide and determine whether or not there is an analogous or similar historical tradition of regulating that type of regulation. In this case, question would be, is there a history of prohibiting or regulating firearms in libraries in this country? As it happens, since that Bruin case in 2022, there's been, I hate to use the word exploded, an explosion of firearms litigation with hundreds of cases all over the country. And all because this is a new legal standard and it has to be litigated and explored in the courts to figure out what it means. And it's not entirely clear. There's in fact a new, unusual, the US Supreme Court is taking up another case on the exact same subject. It just had the argument in December, you would expect a ruling by June. And I think they did that in part because they recognized that courts are reaching all kinds of different conclusions under this decision they issued a couple of years ago. Having said that, I was able to locate a couple of cases. So back just a half a step. One of the things that the court in Bruin said, and which had been said in a couple of prior cases, was one of the things that you can regulate, the government can regulate, is firearms in sensitive locations, sensitive places, right? And it listed a couple. It said sensitive locations, I think, such as courthouses and government buildings were the two that it listed. Or no, schools and government buildings. Sorry.
Who wrote that?
That was the U.S. Justice Alito originally. Sensitive places such as schools and government buildings.
Yeah.
Originally, though, backtracking, that was originally Justice Scalia's language. It was being quoted. He wrote first. The point being that, okay, schools are fine, right? They named schools specifically. Government-owned buildings, probably fine. Courthouses, things of that nature. The legislative buildings, other government-owned buildings, probably okay. Libraries, not so clear. And there have been two cases that I could find where three states, but two that have been litigated, New Jersey and California, both passed after this Supreme Court decision, lengthy lists of sensitive places where they were going to prohibit firearms. Okay, they responded to this, said, okay, fine, we can limit firearms in sensitive locations. Here's a very long list of what we're going to decide are sensitive locations. Libraries were among them. New York did too, but that one, New York did as well. Yeah. New York, New Jersey, California. But the two court cases I found involved New Jersey and California's. They went through these locations and both of them said libraries were not okay. And said that they couldn't find any historical parallel for the regulation and prohibition of firearms in libraries. And the government tried to say, well, the regulation of dangerous places generally might be okay to sort of form a basis for the government to regulate them. And that points up the whole problem with the Bruin decision, is it wasn't clear about, well, how close a fit does it have to be? Does it have to be that for the last 200 years, we've said there have been laws saying no firearms in libraries? Or can it be something more general and says, a sort of general authority to regulate locations? One of the rationales stated was, say, a location where a lot of people may gather. Could that be, sort of similar enough? And it's unclear. That's what the Supreme Court's going to, I hope, will give a little more guidance on in the next few months. But so these aren't decisions that are binding on Vermont. It's a New Jersey case and it's a California District Court case. They aren't even appeals court decisions, which are generally even more weighty, more influential. They're trial court decisions, but they were, detailed explorations of the issue. They were looking at it, and they both said that the attempt to prohibit firearms in libraries failed under the Second Amendment Bruin test that had come out. Not binding on you, but you should know about it. So that, for example, in the Judiciary Committee, there have been numerous statutes related to firearms that have passed over the last couple of years, and the committee has taken this knowledge into account that there's going to be some uncertainty, likely to be litigated. People are going to bring court action. They won't know for sure whether or not that's permissible until the court tells you. So it's really a matter of how comfortable do you feel with that uncertainty. And I think it's Senator Sheep will recollect they passed several things in the Judiciary Committee, and the legislature has passed several items over the last couple of years, knowing that ultimately the courts will have something to say about it.
And Mr. Secretary, what has been the outcome of those decisions that have been made by the General Assembly in the courts when they have been challenged?
So far, they have been challenged, but the courts have, stepping back, pre-Bruin.
Pre-Bruin.
Pre-Bruin,
What year was Bruin?
2022.
Okay.
But there was several challenges, and in the years leading right up to that, and the legislation was all upheld. So it was okay under the Constitution. The stuff post-Bruin is still pending, as far as I know. There have been cases brought, but I haven't heard of any decisions.
Pre-Bruin, has anything been appealed?
To the Vermont Supreme Court, yes.
Just to the Vermont State
Yeah.
Court, okay,
And they upheld it.
yeah, and then it stopped.
Yeah.
They have not taken any other, okay,
Exactly.
great.
Yeah.
Senator, if you will.
In Senator
Thank you.
Williams's situation, thank you.
Sure.
Couldn't your librarian, assuming she knows the patrons, right, small town, she knows Bobby who lives down the street. Couldn't he be one of those, authorized possessions in the bill? So like, she wouldn't have to tell him that he can't bring a,
Don't think
No?
you can do that. So, I think the biggest concern would be that as soon as you make building a gun-free zone, like people, you could put a sign out that says, make it a town ordinance. Nobody allowed in here with a knife or firearm. And if the ordinance is passed and they violate that, then they're violating a trespass order. They could be in violation of that, but.
but it does say that the librarian can authorize possession for specific occasions.
Or
Or,
Well, I think maybe what they'd be thinking about that would be like a hunter safety course or something, but.
Not a blanket.
The way I'm reading it, but I mean, even if it were a blanket, I am still seeing still understanding what Eric is saying regarding the constitutional concern, because even if there is a library that says, it's fine, folks can stop in if they're carrying a gun, it doesn't matter. But another town that says, no, you can't come in here with a firearm, those are the towns that could potentially, I think, encounter an issue. But as I'm reading it, you know, it's directors of a public library
Yeah.
authorize possession or use for specific occasions or for instructional or other specific purposes. So,
So they can authorize this.
So, yeah, but, you know, you can't identify somebody that, you know, Billy Bob down the street was a good guy and carries a gun, you can't then, you know, discriminate against somebody else that you don't know. And that's what I'm saying, is honest people that know that you're not supposed to have a firearm, they're not gonna bring a firearm. But the people that would cause somebody harm, the reason for having the prohibition, they're not gonna, they don't care whether you have a firearm or not. You know, they don't care if it's good for you or not. If they're gonna do the environment, they're gonna do it.
yeah, I'm aware of that.
Yeah.
It's talking about the fact that generally there are some librarians who don't want people with guns in their libraries and would prefer calling the cops instead of depending on vigilante justice. So that's another perspective.
So we have to decide to keep this position in or take it out, or?
Yeah, I mean, be good to sort of at least poll folks to get a sense of what they're thinking. We would, this would likely, this bill, it has to leave us by next Friday, because if it isn't, it's going to judiciary. I would think it would go to judiciary, and that would give that committee a week to look at it, and then it would have to go to approach. It could go to approach after that, but we need to, I believe, and this is more of a John Bloomer question, but you may know it, every policy committees need to be done the week after town meeting week. But I'm not sure if it's the primary policy committee or if judiciary would have a little more extra time. You know what I'm saying?
Yes, but I don't know the answer to that
Yeah,
either.
yeah,
It's a
I'll
good
check.
question.
Yeah, but we want to give judiciary a little extra time to get in. Thoughts?
I'm okay leaving it in.
And to Senator Gulick's good question about the part having to do with authorizing, I just want to be clear that I understand this. A librarian could authorize someone to keep their gun if it's even unrelated to an event, what am I thinking? I went through it as a kid too, gun safety event, that kind of thing. As written.
I would read it as for specific occasions.
Yeah.
So, or for instructional or other specific purposes. So probably one could read that as saying a specific occasion. You, person A, on this occasion can carry your firearm in the library.
I've got a firearm on me. Gotta go pick up my daughter. She's in there, you know, can I come in? That sort of thing. Right? I mean, a specific occasion, a specific circumstance, that,
Yes, I would read that way, though, and this may not be the language you have either, but the prior to that, and
we
you
have
folks
not
would know this
changed the
better than
language.
me.
What's that? Yeah, go ahead.
Does it say, still say, if the governing body, trustees, managers, or directors of a library authorize?
Yes.
Yeah.
So I don't know, I'm not familiar with library governance, but to me, that does not seem like a librarian making an on-the-spot decision. It seems more like a policy call by the people that run the library. Good point. I don't know.
So the hunter safety is gonna meet in the basement this weekend. Please come, one, come all, bring your guns so that you can learn properly,
Right.
clean them, etc. Or there's
We're gonna have a speaker on Tuesday night who's talking
Gun
about a
safety.
book related to firearms. People may be carrying that night. That's okay.
Yeah.
Some occasion. Yeah.
Yeah, I mean, just the way I'm still reading it is that it can be generally authorizing possession. And, you know, so if a librarian or the board of directors say, you know, it's fine for folks to have guns in this library, that's our decision. And compared to another town where the folks there say, we don't want that, and so we are going to set up these signs and. And you know, with that being in effect, then it would be considered the sensitive area. And you know, I can see how that would make sense because there's not a one size fits all policy for most things, in my opinion. So I think it gives more license to do what the town or what the library thinks is best
Got
for
it.
their community.
So you might live in a particular area and then that board of trustees can decide whether or not they want firearms to
They can authorize.
authorize or not. Is that true?
You mean, would this language permit the governing body of the library to just say, we think firearms are okay in this library?
Yes.
I don't read that.
You don't
Oh,
read it that way. Okay, that's important. Thank you.
But it could be spun that.
It could be written that way.
Absolutely. If
Yeah,
you want
it's
to do it
not
that way,
written
I
that
put a period after
Okay.
the word use. Just saying.
I'm sorry, where are you?
I
Page,
see where it's, okay.
Just say possession of firearms.
Use.
It's okay, will be okay. Will not apply to possession use
I
if
see.
the bodies agree with.
oh,
authorize
here,
it.
That's
use,
so
and then
funny.
get rid of.
I was reading it like,
Yeah,
okay,
now, yeah, okay. now-
Yeah.
or
Oh,
authorized
okay.
possession,
Eight,
comma.
nine, I think it's a constitutional issue. And I think you're gonna get in trouble with it.
Are you at all more comfortable, given what Mr. Fitzpatrick just said, by changing this language, then we are allowing, like Rutland Town could make their own decision around firearm use. Bennington could make their own, and does, you know what I'm saying?
I still think
You still-
it's a constitutional issue.
Okay. Yeah.
So I'm not sure if you're ready to do the straw poll.
No.
Okay.
I like,
But no, yeah, go for it. It's a straw poll. No, let's get
Well,
everything.
you already have one,
I've got two now.
got two. Okay, so I've got quite a history of weapons training.
Yep.
Okay, just from background. And I'm not a gun carrier. I've never felt the need for that to ever move with a concealed weapon. But there are very stringent requirements, state and federal requirements about gun carrying
Mhm.
that I think we should be able to rely on that system to vet those that are, shouldn't be carried. And that I trust that system as opposed to legislating that all libraries should be clear of concealed weapons. That's
Senator Sheets.
Yeah, I'd like to read a bit, my answer is I'm on the fence, because I'd like to read some of the cases in which the two cases in which libraries were not considered sensitive locations. I mean, I know they're not in our circuit, but it would still be a good idea to get the reasoning behind the opinion. And then just see what it says, but I mean, philosophically, I want to be clear, I don't think people should, I want to respect what my librarians have asked for, which is they want to prohibit guns in the library because they've listed their reasons. But I also want to make sure that we're not passing something that, then the board of trustees or the librarian makes a decision and then it leads to a lawsuit for the library in the town. So,
Okay.
yeah.
Yeah.
I think on the fence.
Yeah, sure. Senator, Joe, were you gonna ask?
Yes, please, wouldn't it be a lawsuit for the state though?
I guess it depends.
But,
If the library was the one, but actually that would be a good question for Eric.
Could be both. Probably in all likelihood. Not predicting the future, but I think in all likelihood, if it were to be challenged, it would be challenged statutorily on its face as a unconstitutional state law. On the other hand, if a particular librarian said, say somebody went to the librarian and said, hey, you have the authority to permit firearms under the statute that you just passed, so can you allow us to bring them in? And the librarian said no, well, then that could make the librarian the defendant too, you know, so it could be both, depending on the facts. And just to, I think I said this, but just to reiterate the point, while the say some change in the language of allowing some discretion on behalf of the librarian kind of addresses that issue of allowing, that the committee is talking about, of allowing the librarian the ability to do that. The underlying Second Amendment question is still gonna be, so I don't think that will affect the Second Amendment piece of the argument. But again, you don't know what the future brings on that, so maybe okay, Mayor?
Sorry.
I guess, one question I'm curious about is, so hospitals are considered sensitive places, and has that been upheld in other states? You happen to know?
I think there has been a case or two that's found okay in hospitals. Yes,
And so I'm wondering if, just thinking about the reasoning, I mean, a hospital is open to everyone, anyone can walk into an emergency room. Obviously, there's a different type of sensitivity because, you know, it's a place where people's health is at risk and they're, you know, trying to get better or address an injury. And a library is also a place, not where people are trying to get better, but it's open to everyone. And so, and this might be in the opinion, but is that why hospitals are generally considered more sensitive than libraries, or any thoughts on that?
I'm not sure, I'm not even sure if because as I think about it, I haven't looked at hospitals for purposes of today, so I don't wanna imply that I've looked at it that thoroughly recently. But I think there've been some mixed results in hospitals as well. So it's not sort of a uniform, generally okay. It's more of a that, there have been some mixed results.
Thank you.
Yeah, sure.
Yeah.
We'll just closing statements. We wanna think about, or we often think about gun incidents as being like an active shooter entering a building, but, you know, recently we've had these examples of mass shootings where it's been an argument that is broken out. The one after the Super Bowl, for example, between two people, and, that is something that could ostensibly happen in a library, and libraries are becoming more and more sort of this open space for lots of folks, lots of desperate folks, lots of, you know, in a place with kids and little kids who are there for their morning reading or sing along. And it's just to me, it's a very precarious situation. And so that's, again, I'll just say it again, that's why I support this. Especially with our carve out for, you know, specific occasions, or instructional purposes, but I just think it's really important, that we pay attention to, you know, keeping our kids safe, and our families safe that might be in a library with, you know, a panoply of different kinds of people.
Yes, Amber.
So that, what you just explained could happen anyway, you know, just the municipal library in my town is parked around Main Street. They can still have a firearm in their, so they can get into an argument, they can go out and get their gun, come in. You know, it's, I still think that you can't, that we should really be careful about prohibiting. I don't know, maybe if you leave it up to an individual library, then if there's a lawsuit, they would sue the library, but I'm not in favor of the state government mandating every library in the state becomes free zones.
Yeah, just to kind of tag on to your comment, I understand that, but kind of where does it go? What's the next step? So I understand the logic, but McDonald's, Starbucks, public streets, you know, we're everywhere. And if the logic for concealed carry and all of that, you know, the legalities of concealed carry and what have you, stand the test of Constitution, it's very difficult to chisel out sanctuaries where it's not appropriate. I just see it as a very slippery slope. I don't get the logic that, library is different from public street. No, it's one thing.
A library provides programming, specific programming designed for kids and families. It's part of their mission
Public
and
space,
vision,
right, we get it, but it's,
so that's a little different from the street.
Catherine, nice to see you.
So
You know the topic that we're talking about?
I do. I thought it was starting a little later. I'm sorry to have arrived midstream, but would you like,
I'd like to know what the library, what the study committee and the position of the library, state librarian is.
absolutely. The working group was unable to reach consensus on the topic.
Okay,
The working group heard from librarians around the state about many, many things. Not very many people, actually, no people provided feedback on the topic of safety. The topic of social services was something that people provided a lot of feedback about, and some of the testimony that was received, the written comments about the safety topic were actually really about mental health and really in the social services realm. But on this specific topic, there was no feedback received by the working group. That said, the working group did take Senator Hashim's request to add safety into its consideration, even though that bill didn't move through, we added a day to discuss safety. And there were people on both sides. I think a couple of weeks ago, we heard from a librarian in Pulteney about the challenges faced. Safety is definitely a challenge, and in rural communities, the response times of the police are really something that we do know. We did hear at different points in the working group's meetings. A librarian on the working group from Colchester expressed concerns that implementing this type of legislation to prevent guns in the library could make some members of the community feel unwelcome, could make people with certain political opinions feel unwelcome. She expressed concerns about that were, I could share her name with the committee if you wanted to hear from her specifically. Other people felt very strongly, more along the lines of what Senator Gulick was just sharing, that this is a place where school groups come, children come, they come as a group to public libraries. Many school libraries have very few resources, and so students come to get support and do their work in the public library regularly. There are programs and services for families. The department doesn't have a specific opinion on this at this time because I was, and I will be listening to anything I missed, hoping to learn more about the topic of gun laws. However, I am concerned about the constitutionality of it, and I do want to voice one other concern that is my own based on my perspective and my experience serving people experiencing homelessness in a different state. But I feel it's important to share. Many people who are living outdoors who do not have homes carry weapons with them that they must use to eat, to cut food, to do all manner of things. They are an important part of our community. This isn't just about gun violence. This is about other weapons. And I don't know, I know in San Francisco how long a knife could be to come into the library, and there was local law around that. I would just be very careful that when to really consider who we're impacting with legislation, because I want everybody in Vermont to feel welcome coming to the library, people on both sides of the political aisle, and also people on both sides of the housing situation. I want people who are experiencing homelessness to be able to use the library, to be able to bring their bag with their possessions into the library. If they leave things outside, there's nobody there watching their things, they could be taken. And that's a concern that's very real for people experiencing homelessness. And they are some of the highest need people in our community. And I have some concern about this legislation, and I don't actually understand how it would impact someone who had a knife that might even do some hunting with the knife, depending on where they live and what community they're in. It's a concern to me that there is sometimes a conflation of the experience of homelessness with poor behavior. I do not think that that is always the case. I think that we really need to split those two things apart. And I know that this committee's been very focused on the gun aspect, but I would call your attention to the deadly weapon aspect as well. There are other deadly weapons that are not guns.
Senator Chu?
Yes, for the record, I didn't need to conflate homelessness and other desperate people with violence at all.
No.
But is there, would it be what's the word I'm looking for? Not appropriate and maybe even sort of like demeaning to ask someone to leave a weapon at the front desk in the same way that we're asking kids to leave their cell phones when they go to school, like, you know, at the office, or is that, it seems like it's pretty inappropriate to ask that of an adult, and yet I'm just trying to think of
Yeah.
creative ways around this situation.
Well, if I may, my not being great with guns, if I were behind the desk and somebody brought a weapon in, I'd feel safer if the person who knew how to deal with the weapon, just personally.
Yeah, no, I mean,
Then, and the person, if they handed it to me loaded or something, I'd be worried that
I was thinking more of like a knife or, but yeah.
Senator Sheen.
I just wanted to express my gratitude to the group for looking at the language and discussing it, and also thank you for bringing up the dangerous deadly weapons and the knives and I don't, you may have heard from previous testimony, but you know, for me, this was, the origin of this came from some constituents who were concerned about specific incidents of firearms coming into the library, you know, while there were kids there. And so that's the origin, and your points are very well taken. And, you know, even though I did or, cause this language to, I guess, be put into this, I'm still on the fence and, with the constitutional concerns, as well as now what you're raising with the knives and yeah, so I appreciate that. Thank you.
May I say one additional thing? I do want to be sure that I represent the voices of librarians who have raised significant safety concerns. And I want to share, Senator Gillick, it's not you that I was saying sometimes conflated things. I think that sometimes there is behavior in libraries that is wildly inappropriate for the environment, and that people need support in addressing the behaviors. They need support in dealing with mental health issues, dealing with financial insecurity, food insecurity, housing insecurity, mental health. And librarians need support from local, municipal police and from state police, if that's how they are policed, and responding quickly. Librarians are not police officers, and I think, it is challenging. I used to have to collect skateboards from kids because we couldn't have skateboards in the buildings in San Francisco, and just getting a skateboard. I actually had to call the police once when I was attacked by a full-grown man with a longboard. So if that's how people act about their skateboard, we probably don't want to get into the space of asking for a weapon. And then also we would need a place to lock the weapon and training on handling it. So I think that would be hard for librarians. I also think it would be a little bit difficult for Vermonters to have a library by library approach to this, with each public library in each town acting differently. As far as did the trustees decide this is one of the gun-free libraries or not? That might be difficult for the community.
We
but
didn't give hospitals any kind of flexibility, correct?
Correct.
Thank you.
But I just want to be sure that everyone hears that there is a need for safety in this public space, as there's probably a need for safety in other public spaces. But we have heard a lot from librarians that they are concerned, and from trustees and library directors, that it's hard to ensure a safe workplace for their employees, and that it's sometimes challenging to invite in groups of children because you can't always ensure the behavior is going to be suitable with the public. So there is a public safety issue. I'm not well versed enough in constitutional law around the Second Amendment to know if this is the appropriate solution.
Eric, when hospitals popped up, I think, when you all looked at that,
Yes.
how involved was, I guess my question is, we can put our opinion forward. In the end, judiciary largely, this is gonna have to go down there.
Sure.
Was health and, did that happen last
I
year?
think we did that. Helped a lot.
That's,
And then it just, and then it
35.
went down. It was, I think it was,
36.
okay. And then it went down the hall to.
Exactly.
Okay.
Exactly, right, yeah. Similar kind of process you're thinking about, yeah.
Great. Anything else from Mr. Fitzpatrick at this point?
Did you want a moment on the other?
Oh, yes, please.
The other,
Apologies, yes.
criminal justice
Yeah,
piece in
thank
there?
you.
Yep, sure. And I think it's at section 7 in the amendment. Yes, criminal threatening, exactly. So this also is a proposed addition to a statute that is already on the books. This is the crime known as criminal threatening. And although it's not reprinted, or at least it wasn't in the bill as introduced, probably still isn't, the offense itself is when you knowingly threaten another person, and as a result of the threat, you place the other person in a reasonable apprehension of death, serious bodily injury, or sexual assault. So, but it's not just a threat without any result, it has to be coupled with the result. And it's not that it subjectively causes someone to think they will be the victim of an assault. It has to be objectively, which means it's a standard legal concept of a reasonable, has to have been reasonable for the person to have that reaction. So reasonably put someone in apprehension as a result of the threat that they're going to be either killed, seriously injured, or sexually assaulted. That crime is a 1-year misdemeanor. So maximum 1 year in prison for that offense generally. However, and this is the piece that goes to what's in S220, there is an enhanced penalty. It's a 2-year misdemeanor if you threaten somebody in a list of these particular places. And this is existing law. It starts over, well, I don't have the right page. It's in subsection D, probably, I think, of what you folks are probably.
Page 4.
Oh, great. So, and you'll see that it says, if you violate this section, in other words, if you commit the offense I just described, you commit criminal threatening by making someone reasonably think that they're going to be killed or seriously injured or sexually assaulted. And you do it in any one of these particular places. You see public or private school, post-secondary educational institution, place of worship, place of polling during an election, state house, federal, state, or municipal building, then it's a 2-year misdemeanor. See, so it's an enhanced penalty. It's a more severe penalty if you do it in one of these sensitive locations. And so the proposal, as I read it, is just to add public library to that list of places in which if you commit the underlying criminal offense of criminal threatening, you have a more severe penalty.
Yes, and actually.
I mean. Yeah, I'm thinking about. What, will this deter somebody from acting in such a way to do that, to act, to make these threats? And what I'm getting at is, if somebody is making a threat that places another person in reasonable apprehension of death or serious bodily injury, they're not thinking in their head, all right, well, this is only going to be a 1 year, jail term, but it's looking like I actually might get 2 years because it's in the library. I don't think I'm going to make the threat that I was going to make. And I mean, I'm all for public safety, but I also don't want to over criminalize behavior that, might be. Yeah, I'll just say, I don't want to over criminalize behavior, but yeah, I don't think it's addressing the root cause of, why criminal threatening might happen. It can happen for all sorts of reasons, but yeah, I don't know if that would deter people necessarily, but I mean, if there's evidence that it would, then I'm fine with supporting it.
Ms. Dunn, do you mind if I just call Ms. Daniel first? Please go ahead.
I wanted to clarify something that may be about the existing law. My understanding is that in the existing law, all municipal buildings are already the staff working in any municipal building already has this enhanced protection from criminal threatening with a heightened penalty of 2 years versus 1 year. 70% of the libraries in the state are already covered by municipal buildings. The working group made the recommendation to look at this because the 30% of staff in incorporated public libraries do not have that same enhanced penalty. And there's a confusion for the public because the public typically walks into a local incorporated public library and is yelling about things that have to do with the municipality, and they're upset that the city clerk is closed at 7 o'clock at night, but here they are yelling at the incorporated library staff member who's not even a municipal employee about things in the municipality. It's really just to cover all of the public libraries in the same way.
Okay.
And that was the recommendation of that was what the working group was looking at. And I believe there was a specific recommendation about this
In-
for that reason, yes.
Okay.
Senator Williams?
Oh, just, this is just an addition. It's not existing law right now.
It's
That is
existing
fine.
law for municipal buildings,
Right,
of which
now,
70% are library, 70% of the libraries fall into that category, so this will be capturing the rest of the libraries.
So I'll bring people back to S36 when we took testimony from, about threatening or injuring a hospital employee. Or
Uh,
that question was asked of one of the testifiers. So do you think that passing this law is actually gonna protect you from being injured? And they said no. Well, we passed it anyway.
that's right, you all did that last year.
We did a joint
Yeah.
judiciary and health and welfare. So.
Yeah, yeah,
Thank you. That was gonna be my comment, was we took a lot of testimony though, that nurses and doctors were getting
Yeah.
physically attacked and abused.
Right.
And assaulted, which is how we ended up where we did, but I don't know if that's the case in the libraries, not that that should be this threshold, but I mean, it was compelling evidence for
And
us.
it's in law now.
Yeah.
Well,
It's in the
We
same
don't-
statute.
right,
It's further, it's not reprinted in your bill, but it's in, that was added to this statute last year.
but we don't know if there's still been
Right.
injuries or threats.
I think I might have, yeah, please,
Yeah.
sorry, go ahead. Please.
No, I was just going to kind of summarize it. While I agree with the premise and the philosophy of the addition, it's not gonna have any net effect, just like we heard in testimony. So we can do it, but it's not gonna affect, the next library incident of outburst.
What? So we have to know whether or not S36 has had an impact on hospitals, right? If S36 has had an impact.
But
on
maybe a little
hospitals-
early to
Might be a
say,
little-
but
yeah.
I mean.
Yeah.
And,
Yeah.
I like the concept, but I don't think it's not gonna.
I mean,
I just want to clarify that S36 changed Rule 3, which affects the rules of arrest. So somebody's throwing chairs at a doctor. And, when the police show up, they don't just get a citation.
Right.
And then the cop
They get
says,
arrested.
see you later, they get arrested, so.
That's right.
Warrantless things.
Which is not
Which is,
this.
they have a constitutionality issue too.
yeah, Senator Julick and I were sponsors of S36. Yeah, that's right. Okay, please.
Just a question, just to show that as an indicator, I'm not familiar with library governance. But was I understanding correctly that so 70% of libraries in Vermont are municipal buildings? Does that mean they are municipally owned?
Yes.
So that would mean it's a government building.
Right.
So just so you know, this goes to the Second Amendment question that I was bringing up earlier. As a government building, there's, at least with respect to government buildings, it doesn't necessarily, the statute, the proposed bill isn't limited to municipally owned libraries. But that was a point that actually was raised in that New Jersey case that I mentioned, because it spoke of all libraries, but the judge in the opinion said, well, might be a different story if it was only municipally owned libraries, because that's a government building. And again, I don't even know who owns the other 50%. That shows you how little I know about the subject, but it's just an interesting
Yeah.
wrinkle to it. 'Cause, a government building does have a stronger argument under the Second Amendment toward being okay to regulate firearms.
It's never simple.
Right.
Okay, so Senator Sheem's gonna look at some cases, take a look at things. Do you want to float this by the chair of judiciary as the vice chair, or do you want me to talk to him?
Well, if you're seeing him,
I see.
Yeah, I can talk.
Okay, it'd be great. Yeah, if you want to talk to him, that would be terrific. As the vice chair, that'd be great.
Just a clarifying question, we're talking about municipal buildings, but that's under the criminal threatening section.
Yes,
So you're saying that's also under the firearm?
not specifically, but just that generally, under the Second Amendment, one of the specific sensitive locations that's permitted to regulate firearms. The one that specifically was recognized in the US Supreme Court was government buildings. So, one could read that as, I probably would, it would be a stronger argument that if a library were owned by a government, then that's a government building.
Anything else from Mr. Fitzpatrick at this point? So, here is an outline. What is this? Of the remaining decision points on 220. So of course, well, we have Mr. Fitzpatrick here, number 1, 2, 3. Third is, dangerous weapon, firearms in public libraries. This was created by Tucker Anderson. We still need to, of course, look at, well, let me put it this way. The very first one I think we need to deal with, if people could give some thought to that, this is the confidentiality piece. Library positions, we're gonna have to take a position as this leaves us. I don't want to keep you. I think we're good.
Okay, thank you.
You're
Well,
welcome.
I'm happy to come
A lot
back
of people-
anytime.
Okay,
Yeah, so
Great.
any other questions come up or you wanna,
really appreciate it. And
Absolutely.
Senator Sheep's gonna take a look at some cases as well as talk to the Chair of Judiciary.
great,
Timing, I'm gonna talk to Secretary Bloomer about when this would need to leave.
sure,
We'll go from there.
all right. Well, let me know, good luck, I'm happy to help out.
Would you mind just
Thank
emailing me
you.
the names of the cases?
Yeah, so I was thinking, yeah, I'll send them your way,
Thank you.
sure, you bet.
So then we get to dangerous weapons, library governance, whether to include some language clause that would clarify the level of funding in municipality centers. May recall that there was language that might cause, there was some vague language around requiring maintenance of libraries, which I don't think it's gonna be very controversial. I think we can do that pretty quickly. Department authority, Mr. Anderson's gonna connect with Senator Weeks on how to update the collection diversity language. And then appropriations, this will of course need to change depending on what that means in the bill. So the big thing I think, just for everybody to sleep on tonight, the confidentiality. And the weapons, if we could sort of get there sooner rather than later, that would be great.
Oh, weapons.
On the weapons, yeah, and we'll come in tomorrow and talk about it a little bit, but like this to leave next Friday at the latest, because it's gonna have. And it looks like we're almost ready to do technology, we're almost, I think, ready to do. Your bill that we're about to take up with, Tom. And then we've got literacy that needs to leave, and then we've got all of our other smaller things, important bills. Lisa.
I thought it might be helpful just to bring folks back to the intent of this bill, which was to really, take the report from the library working group and enact as much of the various suggestions in a bill as possible. Yeah, I don't know if that's helpful,
But as we've heard, the bill doesn't really reflect that. Correct? I mean, the bill reflects, so like this issue, if the library group was undecided.
Right, there may be a few
Yeah,
issues
yeah,
that are, but most of the
Yeah.
Yeah.
provisions
And,
are.
and I think too, for us in the library community, I think I can speak for everyone in saying that having your attention and thought on these matters is important. So even in an instance where we didn't ask for a specific recommendation, we were really turning to you to consider things and make decisions about those. And you've been having thoughtful conversation, and I think this is to the good and what the working group had hoped for. We had asked for you to consider these specific aspects like the weapons and criminal threat. So,
Fantastic.
thank you.
Did you connect with Rep. Brown?
Yeah, she would have talked, she couldn't come today. She couldn't come. She had a meeting at 2:30, and then did she email you?
Okay. Scott, do you mind if we just take 2 minutes? I need to run down the hall.